I'll be presiding this afternoon. To my right is Dave Furman. To my left is Nancy Lichtenstein. We comprise Division 5. We have 3 cases on the docket today. The first case, 17CA0757, is Colorado La Paloma versus Board of County Commissioners, and I assume that council are here and ready to argue that. Okay. The second case for the 1:30 docket is Donahugh versus Board of County Commissioners. Same thing. Is it the same council, by the way?
Yes. Same terms.
Okay. And the third case at 2:30 is Neuhoff versus Board of County Commissioners. Is it still the same council?
Yes.
All right. So let me ask you this then, in case the answer is different for each case. Will you be dividing time?
Yes, Your Honor.
Okay, for each case?
For each case.
Okay. And how do you intend to divide it?
Well, the intent is that Eagle County will present first, hopefully leaving at least 6 minutes or so for the AG's office to present on behalf of the Board of Assessment Appeals.
Okay, very good. And to everybody out there, I would ask you to be sure to turn off your phones or anything else that's going to make a sound that would be distracting to the attorneys and to us up here. Also, this is being live streamed, so keep that in mind, counsel. And also, it's going to be archived, so if you want to go back and watch it later, you can do that as well. I assume there are no questions about the court's policies or procedures, is that right? Okay, then we are ready to proceed with the first case, Colorado La Paloma versus Board of County Commissioners.
May it please the court, I'm Britt Clayton with the firm of Riley, Carlock, and Applewhite, registration 15940, appearing on behalf of Colorado La Paloma, Inc. This is a statutory interpretation case under the Residential Classification Statute CRS 39-1-102-14.4a. 2 elements of the statute are disputed in this case: common ownership and used as a unit. I'm going to briefly address the common ownership element first, and then the used as a unit element, where I will answer the 2 written questions the court has presented.
Okay.
On the common ownership issue, a different configuration of Division 5 recently issued a very cogent opinion in Kelly versus Summit County, holding that the determination of ownership in this residential classification statute is not limited to consideration of record title. Rather, ownership depends on who has the right to possess, use, and control the property. We cited Kelly in a recent notice of supplemental authorities. In the interest of time, I'm not going to reiterate the legal reasoning of the Kelly decision, but we do endorse and adopt it insofar as it goes.
I have a question about the common ownership. I'm trying to understand its outer limits, I guess, if you will. My understanding in this case is that La Paloma, the corporation, is owned by Joaquin, right, of Lila?
Yes,
But not by his wife, Isabel.
correct.
And the other land that is at issue, the residential one, is owned by both of them by virtue of a transfer. So the issue there is their common ownership, and I get that. What I'm wondering about, looking at sort of the bigger picture, as we have to do back here, is what do we do with fractional interests, which are all over the place in Eagle County and other counties, where he may be one of 10 or 25 or 52 people listed as fractional owners. Would we have common ownership then as well?
Well, in my experience, the fractional ownership issue comes up typically in the case of condominium ownership, and not with these more rural assemblages of land.
But it could.
It could. In theory, it absolutely could. What I would say is that the way that the term common ownership has evolved to have this well-understood meaning and the General Assembly using a term that had a somewhat amorphous boundaries. We are going to have a somewhat amorphous definition of this term that may have some close cases that have to be decided later on. I think that with respect to these three cases, when you have, or this case, when you have the Blyas, all across the board, it's not a very hard case. If you have a fractional interest where, let's say, a 1/10 interest owner in one parcel and they own 50% of the other one or 10% of the other one, I think what the Kelly decision would ask you to do is look beneath that to what extent is there commonality in the use and possession and control of it. Can this individual use and control both parcels? Are there other fractional owners who add to the commonality between the two? So I would acknowledge, Your Honor, that at the outer boundary of this term, there are going to be close cases. There is clearly a boundary beyond which you would not have common ownership. General Motors and one of its shareholders do not have the sufficient overlap to make that work. So I know the court is always concerned about the unintended consequences and slippery slope, but the General Assembly chose to use this term, which has universally, every time it has appeared in a statute or in a case that we could find, it has been used in this amorphous, inclusive way. Not one case, not one statute has interpreted or used this term in the way that the appellees suggest. So the Kelly case gets us past the record title and invites us to look at the substance of who uses and controls and possesses the property. And under that test and the fact that Mr. Blya controls the corporation completely and half owns the other parcels, this case would easily satisfy that test, that meaning of the term. Turning to the used as a unit element. It's undisputed that if the three parcels involved in this case were instead a single parcel, the used as a unit element would be presumed satisfied for 100% of the land. The fundamental legal question this court has to answer is, does the used as a unit term in the statute have a different meaning when there are multiple parcels rather than one? First, we look at the statutory text, of course. A parcel of land and contiguous parcels under common ownership are grammatically interchangeable. They're treated the same. The used as a unit element that follows applies equally to both. We next look at case law. Gurman, Farney, and Fifield take a very accommodating approach to the types of uses that support residential classification. There's no indication in those cases that there's a different standard in the two situations. The recent opinion from Division 6 in Rust versus Summit County does hold that the multi-parcel situation should be treated differently. With due respect to Division 6, Rust was incorrectly decided. Due to the limited time I have here and the fact that I'm going to see you again in the other two cases, I'm going to explain in some detail why Rust is incorrect in the Donahugh argument coming up next. But we continue to maintain that the used as a unit statutory language has the same meaning in single parcel and multi-parcel cases. Which brings me to one of the court's questions. Assuming that view protection and other non-observable uses are sufficient to meet the requirement of residential land, what would be sufficient to rebut the presumption that the county assessor correctly classified a parcel as vacant land? Evidence Rule 301 and case law under that rule addresses presumptions as follows. A presumption imposes upon the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption, but it does not shift to such party the burden of proof in the sense of the risk of non-persuasion, which remains throughout the trial upon the party on whom it was originally cast. As a result of the presumption in favor of the assessor's classification, the taxpayers in these cases have the burden of going forward with evidence and the ultimate burden of persuasion by a preponderance of the evidence to establish facts that are sufficient under the statute. And if you agree that the principles of Gurman and Farney apply in the multi-parcel context, then what a taxpayer needs to do specifically is to go forward initially and ultimately establish a use of the subject parcel that satisfies the standard of Gurman.
So is a buffer a use?
It is. Buffering is actually a widely regarded, respected use. Parks, open space, within developments, you have buffering land uses.
So what's the role? I've been trying to figure out what the role of the counties and of the Board of Equalization is in this context. Because the legislature could have said a parcel or contiguous parcel of land under common ownership shall be classified as residential land. And that would have been it. But instead, they went on to say, and when used as a unit in conjunction with residential improvements located thereon. It's that addition, then, that makes me wonder, what is the role of the county here and of the BOE and of the BAA if they can simply say it's a buffer? Why doesn't that end it at that point, then?
Well, let me back up just one moment and say we went through a similar history in the single parcel context. When residential property first got its favorable classification in the 1980s, it didn't take the assessors long to start going around saying, you don't need that over here for the residents, you don't need that over there for the residents, because it makes a difference in the amount of taxes you can collect. This court had no problem saying no. If the taxpayer wants to not look at a neighbor over there and would prefer to look at the wildlife over here, that satisfies the used as a unit requirement. We're not going to have assessors and ultimately the BAA nitpicking people and, well, we think you're going to use this much of it for the residents, but not that much of it. This court correctly said that's not the role of the assessors in the BAA. Now, fast forward 15, 20 years, the assessors and the BAA are saying, well, in the multi-parcel context, though, in the multi-parcel context, we can do the same thing that we tried before. We can say, you don't need this parcel. You don't need this view. Look over there. Don't look over here. This is just nitpicking in the extreme.
Mr. Clayton, well, sorry to interrupt, but let me follow up on what you're saying. What role does the BAA have in assessing somebody, a parcel owner saying, I bought this to be a buffer? And it could be they bought it for an investment and not to be used as a unit with a residential parcel. Isn't that a fact question? And the BAA seems to have taken some positions on all of these with some commonality that you point out in your brief. Yes. That I've seen. But what role does the BAA have in listening and going, well, I don't think you're using it for that?
As a filter for the ridiculous claim of common use or use as a unit. Look, if a developer comes in, right, and he's subdivided some parcels and he put a house on one, he's not even living there. And he comes in and he says, oh, yeah, that's a buffer. Yeah, buffer use is that. You know, the BAA, anybody can look at that and say, no, you're not even living there. That makes no sense. But when you have these families who have bought these contiguous parcels, 17, 20 years ago, and they paid the taxes on them all this time, and the only reason you can possibly fathom they would do it is exactly the reason they're telling you. We like having a bigger yard. We like not looking at neighbors. But it's not up to the BAA to say not good enough. It has to be more necessary.
Could it be that the owner buys a parcel, albeit close to the residential parcel, contiguous or not, we've sorted those out, but for an investment purpose? We're going to keep this vacant with the idea, yeah, I want to sell it. And that seems to me to be a fact question that the BAA in some cases is listening and going, well, I don't credit your statement.
Those two facts, use presently for a buffer and intent to sell in the future for profit, can absolutely coexist. And the law is that the courts and the BAA may not consider a prospective future use. You know, and taxpayers have tried to play the other side of that, right? Well, I know right now I'm using it for this, but I plan to use it for that. And the courts say, no, it's just what you're using it for now. And we're just asking that the same rule be applied here. And the fact that a homeowner might speculatively, or even if they intend to, sell in the future or change to an agricultural use in the future, whatever it is, doesn't change the use on January 1, which is, you know, the standard for use as a unit.
Mr. Clayton, let me just follow up. Looking at the ARL criteria, we've got one deals with the primary purpose of the property and another deals with the actual use. So when we're talking about passive uses, such as enjoying it as a buffer, is the evidence the same on those two factors, or does actual use require something more than a passive enjoyment, say as a buffer?
Yeah, the words purpose and use, I think, are fairly interchangeable. I don't see an intent to distinguish between those. When somebody keeps a piece of property for buffering, they are using it for buffering. If they're getting enjoyment out of it, that explains, you know, why they want the buffer for it. So I view all of these as one and the same question. Well, what are you getting out of it? Why do you have it? Are you using it today for something that German would say is an adequate use? And it's a very low bar. It's a very low bar. It leaves relatively little for the BAA and the assessors to do. I've got very little time left. I will reserve it, and I know we'll come back to these issues in the next two arguments. Thank you.
Very good. You have 40 seconds left here, and as you say, 2 more cases behind it.
May it please the court, my name is Christina Hooper, and I am representing the Eagle County appellees today. My attorney registration number is 38271. I'll be sharing my time today with Ms. Allison for the Board of Assessment Appeals. So the appellant here is entitled to reduction, the reduced residential assessment rate on its improved property only if it's contiguous to, under common ownership with, and used as a unit in conjunction with the residential property as of the assessment dates at issue. The BAA in this case correctly concluded that the subject property doesn't meet the requirement of common ownership and found that the property was not being used as a unit in conjunction with the residential improvements, and therefore the decision should be affirmed. I'd like to start today by focusing on the written questions submitted by the court, which relate to the use as a unit element, and I think that that will then reveal why the board's findings of fact rejecting the appellant's assertion here must not be disturbed on review. And then if time permits, I will discuss why the order should also be affirmed for lack of common ownership under the law. So the board here was not persuaded by appellant's assertions of use for buffer, open space, and maybe some parking and some other physical uses. One of the factual findings the board made that led the board to decide that they weren't convinced that the properties were actually used as a unit was the fact that the appellants purposely put up a fence as a barrier between the 2 residential lots and the 1 vacant unimproved lot. The court is asked, based on the testimony that was presented, that that fence was actually installed in 2015. What's the impact on the board's finding with the respect to 2013, 14, and 15 tax years before that fence was installed? And I would start my answer to that question with focusing on the burden of proof here for the taxpayer to prove that, yes, these past uses were happening as of the assessment dates in question. We're talking about unsubstantiated claims about past use, and in weighing the evidence presented, the board may properly make inferences from all of the objective evidence in front of them, circumstantial evidence as well, and that's just inherent in the role of a fact finder. So in this particular case, it was reasonable for the board, as trier of fact to decide that even though the property owner built this fence in 2015, it still discounts any assertion that the property had ever really been functioning as a unit before that time, especially given testimony that was provided on the record. When directly asked if the construction of the fence had any impact on his use of the property, Mr. Blaya definitively said no, not at all. He clarified now he has to walk around the street to get to that vacant unimproved lot, but he said it otherwise had no impact on the use of the lot. So putting that together with the fact that he put the fence up leads to a reasonable conclusion that it really never did function as a unit. In addition, there was evidence showing that really there was a barrier of trees between them, and you can see that in some of the photographic evidence. Notably—
Ms. Hooper, sorry to interrupt, because I wanted to do a follow-up with what I was just asking Mr. Clayton about. As he points out, the board seems to have not credited a lot of these lot owners in a number of cases. So, can you explain that?
You know, I would explain that by saying that is the role of the Board of Assessment Appeals. Those board members had, in each case you'll see, there were different panels of board members listening to the evidence and going through hours of testimony, hundreds of pages of documents, and the reality of the situation is that the evidence presented was not credible. I think that there was a very similar set of testimony, and you can read that in the transcripts in each one of these cases, seeming to just point to a specific words of enjoyment that needed to be made in order to make the case based on—
Buffer, for example. They didn't seem to accept buffer in more than one case.
Yes, I was going to respond, Your Honor, that there are a few cases where the board indeed was inclined to believe that, yes, this property does appear to have been used as a unit in conjunction with the residential improvements based on the taxpayer's assertion of protecting a view corridor, for example. But I would submit to the court that reading the transcript, it becomes clear that in many of these cases, we had testimony from a property owner, not necessarily even completely familiar with the facts of their own case. Not always were they full-time residents of the property, and difficulty maneuvering through the exhibits. And then we had fact witnesses that were there on a contingent fee basis, things that may discredit some of the testimony that was provided. And those are things solely for the BAA to review in their role as the fact finder and weigh the evidence and the credibility of the witnesses based on what's being provided to them.
Ms. Hooper, let me follow up on that, because certainly the board, it is up to them to determine credibility, and they're measuring it against a particular legal standard. And correct me if I'm wrong, but I'm noticing in the briefing that the position you're taking, for instance, for the meaning of integral part is different from the meaning that the board on appeal is assigning to the meaning of integral part. So if the board is adopting a legal standard and measuring credibility against that legal standard, must we defer to those credibility findings?
For this particular case, I think that the board made very express reasoning that it didn't find testimony compelling or convincing. I think that we had contradicting or conflicting testimony that was provided. Sometimes the tax agent's testimony did not even comport with what the testimony of the property owner. So, I mean, that aside, whether the board is adopting the correct legal standard, we submit that, yes, the board was adopting the correct legal standard, adopting not only taking the interpretation that the Division of Property Taxation put forth in their manual, but also, you know, just reviewing the language of the statute itself that, as Judge Roman has pointed out, was very specific. The statute did not say that contiguous properties under common ownership are entitled to residential classification. That's all that would have been needed if simple words of enjoyment of property rights were allowed. So I guess to answer your question, I do think that the board was applying the correct legal standard, and I think that they were very carefully weighing the evidence presented to them in each of these cases. In particular, in this case, we had a statement from the property owner in direct question to him about whether or not he had a problem allowing neighbors to park on the subject property, because that was one of the uses asserted. He responded, well, if we're not using something and it's available to the neighborhood, I find no reason that we would not do that. Well, very generous of him. That is not a statement that is consistent with this assertion that the properties are being used together as a unit with the residential improvement. So beyond that fence issue, the board had other reasons to support the classification, the decision that the property was not used as a unit. Going on to the next question, assuming view protection and other non-observable uses are sufficient to meet the requirement of residential land, what would be sufficient to rebut the presumption? We first would say, with all due respect to the court, we do not believe view protection and non-observable statements of enjoyment really are sufficient to meet that requirement without a legislative change. We think it conflicts with the statutory directive of use, and then it defeats uniformity. But assuming otherwise for purposes of the question, and we agree that the burden of proof is on the taxpayer. I think appellant agrees with this as well, to show by a preponderance of evidence that the classification is incorrect. But we don't agree as whether the burden of proof has been met by competent evidence as a question of fact. The BAA, I think, to find sufficient evidence of use when it is something that is just something non-observable, would have to look at the totality of the evidence and the credibility of the witnesses. Here, the only evidence that was provided was just Mr. Blaya's unsubstantiated testimony about how they use the property for open space and to control who would be their neighbor. And again, this is just bare testimony, but they didn't find it persuasive or sufficient, while meanwhile the county presented much evidence conflicting just from looking at what is actually happening on the property. And so the board was within their fact-finding province to make the decision that they did. We submit that, and we will get into this in a little bit more when we're in front of you again for the next case, that opposing counsel's reading of the Geierman case is incorrect. The application of the case in these particular cases is also incorrect. And then just finally, to quickly touch on the common ownership piece, we do submit that the Kelly holding in this regard is incorrect under prior decisions of this court, including, and just a plain reading of the language. We don't agree that there's no place in case law or statutes that ownership is identified as something so much more broad as appellants would argue. But even under the Kelly case, we submit that the substance, and the board made this finding, that the substance of the ownership and the right to control is different in these two parcels by virtue of a corporate entity holding one and Mrs. Blaya having no right to control that one, with the couple holding the other two as joint tenants. We ask you not to disregard that corporate form. In terms of the question about fractional interests that Your Honor asked, your question does reveal the very problem with the Kelly case. It would lead to a very big lack of uniformity, and it would be very, very difficult, or if not impossible, and I think contrary to the legislative intent, to try to have the assessor apply that.
You have 4 minutes.
I'd like to turn this over to Ms. Ellison. Thank you.
Good afternoon. May it please the court. My name is Katie Allison, registration number 39430. I am here from the Attorney General's office representing the Board of Assessment Appeals. Your Honors, the subject land was properly classified as what it is, vacant land, in these cases, because the vacant lot was not used as a unit in conjunction with the residential improvements thereon, and it was not under common ownership. More specifically, to give effect to the unit used as a unit in conjunction with the residence element, the petitioner's claimed uses have to be credible, more than occasional use, more than mere peace and serenity or other vacant land uses. They have to be integral to the residence. And with that, I want to get into sort of where we left off, which the discussion of sort of the credibility of the board's determinations and the question about passive or non-observable uses. And I want to just jump right into, I agree that the standard is the petitioner, assuming that passive and non-observable uses can satisfy the unit element. The petitioner could overcome the classification by preponderance of the evidence. The petitioner would have to prove by a preponderance of the evidence that their claimed uses are as they are claimed, and that their claimed uses are used as a unit in conjunction with the residence. And that whole, as you pointed out, Judge Roman, that whole portion of the statute, used as a unit in conjunction with the residential improvements located thereon, that is, the legislature clearly intended to say something there. There needs to be a use. It needs to be as a unit. It needs to be in conjunction with the residential improvements that are located thereon. And also, taxing statutes need to be narrowly construed.
So it's not enough for them to say that somebody lives in the residence and this is a contiguous property with common ownership and it's a buffer and they enjoy it?
I absolutely do not think that merely just saying that I enjoy it, that it's a buffer, is enough. I think there has to be an objective evaluation of the evidence, and that's what the BAA did
But
this
is it
case.
objective or does it become subjective? I mean, it seems like you've got people out there looking over the land and then, you know, showing up sporadically, randomly, and then coming back. I didn't see anybody there, and it almost takes on a subjective feel to it at that point.
Right, I do think there's some element, there certainly is some element, and I think we can certainly consider the subjective element to it. The landowner says, I use it for a view. Mr. Cassidy, the assessor, whoever, says, I don't see that there's actually a view there. But there's also objective evidence, and specifically in the La Paloma case, you know, the claimed view, the claimed passive use of privacy, when you look at the pictures, you see that there's houses all surrounding, and specifically exhibit pages 15, 137, and 139, there's houses all around. So objectively, the claimed use of privacy doesn't seem to make a whole lot of sense. Or for the views, we're talking about a 0.2 acre parcel with, again, residences all around it. Once again, objectively, that view argument doesn't seem to make a lot of sense. And it is, as Judge Furman has pointed out, the BAA's job to determine credibility. The BAA hears all the testimony, they see all the pictures, they're there when people are talking about the pictures, they determine the sufficiency of the evidence, and their credibility determinations should be upheld. I ask that you affirm the BAA's order in this case.
Thank you. Mr. Clayton, you have 40 seconds if you want it for this case.
On the fence, obviously a non-existent fence can't support vacant land classification for the 2013 to 2015. But even for tax year 2016, when the fence existed, it isn't a material factor if the Guerman standard is applied. The fence didn't prevent the Blyas from using the subject for buffering and view protection. The sound and light from that subject parcel comes right through the fence. Look at the photos and the plat map. There's your objective, confirming, corroborating evidence. These are small lots. A house built on the subject obviously would be very visible and audible, and that is enough to support the Blyas' use for buffering. Thank you.
Thank you all for your arguments. The first case, La Paloma, Colorado La Paloma, will stand submitted, and an opinion will issue in due course. You okay? Okay. So we will continue on then to the second case, Donahugh versus Board of County Commissioners, 17CA0758.
May it please the court, I'm Britt Clayton with the firm of Riley, Carlock, and Applewhite, registration 15940, appearing on behalf of the Donahugh family. This is a statutory interpretation case under the Residential Classification Statute 39-1-102-14.4A. The only element disputed in this case is the used as a unit element. We have written questions, or a written question from the court that I will address toward the end of my prepared remarks. It's undisputed that if the two parcels owned by the Donahughs were instead a single parcel, the used as a unit element would be presumed satisfied for 100% of the land. The fundamental question presented is, does the used as a unit language in the statute have a different meaning when there are multiple parcels rather than one? The statutory text says no. No support for a different interpretation in a different context. The case law provides no support for a different standard. The principles of Gurman and Farney can readily be extended to the multi-parcel setting because homeowners use their lands in the same ways, regardless of whether they have a single parcel or multiple parcels. That is the fundamental reality of why the General Assembly would treat them the same. Because kids play and people garden and they just don't want other people on it. It's all the same. There's nothing unusual or different about these families appearing before you today. Fifield noted that its ruling was consistent with Gurman and Farney. Fifield is the case that said residential improvements are not necessary on the contiguous parcels. And Fifield said that was consistent with Gurman and Farney, which reflects an appropriate desire by this court to harmonize the interpretation of the statute in the single parcel and multi-parcel cases. So it is really a small, incremental step to clarify that the principles of Gurman and Farney apply equally in the multi-parcel context. The recent opinion from Division 6 in Rust versus Summit County holds that the multi-parcel situation should be treated differently. With due respect to Division 6, Rust was incorrectly decided for two fundamental reasons. First, Rust erroneously concludes that the Fifield and Sullivan cases hold that occasional use and deriving peace and serenity from an undeveloped parcel are insufficient. Sullivan did not hold anything at all with respect to multi-parcel situations because the taxpayer didn't pursue the multi-parcel prong of the statute. Everything in Sullivan regarding the multi-parcel situation is pure dictum, as the court in Fifield recognized. The court in Fifield also did not consider, even in passing, the types of uses that would be minimally sufficient to support residential classification. The court held only that improvements are not required. So when the Rust opinion states that Fifield and Sullivan hold that occasional use and deriving peace and serenity from an undeveloped parcel are insufficient, that is not at all correct.
Mr. Clayton, before you go on, I understand your position, that's not the holding. What is your position? Is occasional peace and serenity sufficient?
Yes. Kurt Settle's testimony, which I'm going to come to when maybe if we talk about this integral requirement that has been introduced. Kurt Settle's testimony did not appear, first of all, in the Summit County cases. None of the Summit cases did he testify, and this integral concept started taking life. We called him in all of the Eagle cases, including the three before the court today. Kurt Settle really laid to rest this concept that there's a new integral requirement that the ARL imposes, and he really elegantly described or answered my questions describing how even somebody homebound who can't go out and touch the trees, they can't do anything active or physical. All they can do is sit in their home and look out at the forest or the plains or whatever it is and just enjoy that they have this big wide spread and there's nobody on it. That's sufficient. That's no active use. That's purely mental, and that is sufficient. And that ties in beautifully with Gurman, that simply says, hey, I just don't want other people on there. I just want to be able to look at the wildlife and look at it. It's mine. That is sufficient. It is such a low, low standard. So yes, Your Honor, that's my answer. Minimal use, in fact, no physical use, And merely emotional enjoyment is all it takes, and that's all it should take, because that's how an awful lot of people use these large parcels and assemblages. It's just the emotional attachment to it. It's just mine, and I love it, and it's not anybody else's. And I could go out there and do anything I wanted or not at all. And simply feeling that way about your land, loving it and enjoying it in that way from inside the house is sufficient. That's what we're asking you to hold.
So, Mr. Clayton, let me follow up on what I had asked the last time around. What role does the county and the BOE and the BAA play in this? Once you say it's mental, it's visual, I can see it from my house, I can feel it, what role do they have at that point?
Well, they would act as a filter for the case that doesn't pass the straight face test. The hypothetical I gave in the last argument about the developer who isn't even living there. But 99.9% of the cases, when you have the Donahughs, owning both parcels, and they've owned them for 17 years, and it's obvious from the photos that they wouldn't want a house there. Who would want a house there? How can anybody say we just reject the proposition that you're using this parcel to augment your enjoyment of your house? It does not itself pass the credibility test. These three cases at least, the corroborating evidence, the photographs, the testimony of the assessors satisfies the statute. In Donahugh, the assessor testified that building a house on the subject parcel would affect their views and would affect their privacy. And then he and the BAA go on to find all these reasons why that's not important, because you can look a different direction.
So Mr. Clayton, so is it your view essentially that it's a straight face test, the developer, it's that small of a hurdle? I mean, the other situation is we're dealing with a lot of folks who this is a second home and they may be there a few weeks out of the year. Does that make a difference?
No. Legally, no.
Okay. Then are we limited to a board going out one time to see if it passes the straight face developer example that you gave, and as long as somebody lives there some of the time,
Well,
that's it?
Let me say, the straight face test is a colloquialism of mine. I'm not actually suggesting that be the legal standard the court applies. I haven't seen that before. But there is a legitimate appropriate filtering function for the assessors and the BAA, but they have to bring the right state of mind to it. And we have a problem here where we are not getting the right state of mind applied in the fact-finding and adjudicative processes, and then it starts to look like they're changing the law, and they have a hostility to this kind of case, and a big barrier has been erected.
Well, sorry to interrupt, but let me ask about barrier, because let's say the residential lot owner states, I want a view that looks to the west, and that lot owner plants a row of pine trees that blocks that view. Now, the BAA, as the fact finder, is going to listen to this and go, well, your claimed use is not what we believe. We don't credit that. That seems to be the role, at least in the fact-finding role of the BAA. We don't need to go farther if they're saying you're not using it. There's not a filter. They're saying you're not using it the way you're claiming.
Those findings, to the extent they're historical findings of fact, are all clearly erroneous because the assessors admit that the view would be affected and the privacy would be affected. The board is following the assessors to try to find some hook to deny residential classification.
But why would they have an incentive to do that?
I don't know, but
I mean, that's similar to the last case where I was asking, they have a fact-finding role that is very unique in these cases.
yes, but they're doing it through eyeglasses that need to be reground by the judiciary. Look, when you read the board's jurisprudence in the 18 cases, published opinions from the board that we have cited to you, it is very concerning. There's this sort of shtick that's developed where the assessor comes in and says, you know, I went by there and I didn't see the kids playing. I didn't see the sledding. Well, you were there in the summer. Well, I just didn't see anything.
But that's a credibility call. That would be you saying, you're talking one day out of the entire year, and you're accepting that as fact. I
but
mean,
when
that's a
the-
credibility question to me.
But when the board does it in 18 cases, that if you read the homeowner's testimony, is intrinsically credible, and it's supported by photographs and plat maps and all of these things, and often the assessor's testimony, yep, you know, it would affect the view and the privacy. And then the board makes these findings, but it's not important enough, the assessor says. It doesn't satisfy the statute. Then the board makes findings that are kind of like factual, but they're also really legal conclusions. The board finds that the family's not using the home in conjunction with the residential improvements, you know, for view purposes. So they're smashing together this heightened legal standard that they're not being candid about, and the factual findings. And to the extent they're raw, pure factual findings, they are generally clearly erroneous, because the assessors always admit it would affect the view, it would affect the buffering.
Well, Mr. Clayton, what about a homeowner saying that I bought the property so I could enjoy the view from my patio, and there's evidence that there were trees planted, therefore you cannot see beyond those trees? I mean, that the board can make a credibility finding in that instance.
Yes, in the abstract, that's true, but
But doesn't that
There's a-
sound like an inconsistency from the residential lot owner's perspective? You want a view, and then you're doing something to block the view that you claim you want.
well, I don't believe that has occurred in these cases to block views. There was some trees in the Donahugh case on the lower part of the parcel, but if you look at the photographs from their hot tub, you know, up to the expanse, the upper expanse of the lot, one of the primary views, that's not where those trees were. I don't want to get down in the weeds on you know, arguing the credibility determinations. I regrettably have to say that the board has taken an overt position of hostility to these claims. It is, without any necessity, filing briefs in these cases, spending state money to support the counties in the outcomes in these cases. And when you read the board's jurisprudence in its opinions, it reflects an incredulity that itself is not credible. It's just not feasible
But
that all 18 of these families are coming in and lying about their uses of the
But
property.
we have different board members.
Which makes the uncanny similarity in each of the opinions even more odd.
Well, let me just be a little more blunt or frank with you. Are you saying that there are improprieties in the way that they're handling this?
No, I am not. I am saying this. What this means in terms of this court's resolution of these appeals, right? So how does this translate into something in an opinion is this. The taxpayers in this situation need an interpretation of the statute that does not invest abusable discretion in the assessors and the board to decide what uses of land are necessary or important enough to support residential classification. And that's what they keep doing. They keep saying, yeah, it would affect your view, but it's not important enough to satisfy the statute. That can't be. The wisdom of Yerman and Farney in the single parcel context is you no longer have assessors saying to homeowners, you're not using this, you don't need that, look over here instead of over there. It is bureaucratic torment. This is almost Kafkaesque, the way these good families are being treated in terms of, you're kidding me, you don't believe that my kids sled on this hill? I've got a photo of the sled, you know? What do I have to do with this board? We just need the same approach in the multi-parcel context, because the board is going to say, we find the assessor to be credible and persuasive if you get into these gray areas. Is it important enough? Is it bad enough that a house would be built there, if you start vesting that kind of discretion in the assessors and the board, it will be nothing but torment to these people, and unjustly so.
Thank you, Mr. Clayton. Ms. Hooper?
May it please the court, my name is Christina Hooper and my attorney registration number is 38271. And again, I will be sharing my time today with Ms. Allison for the Board of Assessment Appeals. I'm here representing the Eagle County appellees. Based on very conflicting and unsubstantiated evidence that was presented to the Board of Assessment Appeals at the hearing in this matter, the board, as the finder of fact, didn't believe that appellant met its burden of proof to demonstrate the use element. The Board of Assessment Appeals decisions of fact here should not be disturbed on review. The claimed uses, buffer, view, privacy, and the occasional winter uses were all discredited by the objective evidence that was presented. However, to start a step backwards, I will address the court's question first. The question being, assuming passive land, the use of land can satisfy the use as a unit element, would such evidence, if credited by the board, be sufficient to rebut the presumption that the county assessor correctly classified the parcel? Again, to qualify my answer, I would state that the passive use is just not a use as a unit under the statute. It is not synonymous. Use and enjoyment are not synonymous in the context of real property classification. There must be some objective and tangible evidence of use rather than just a subjective assertion. Otherwise, there is no point to the statute. It could not have been the legislature's intent to limit the review of whether use as a unit occurred to just simple statements of enjoyment. There's too much room for divergent opinions about what is a view, what is the view existent, what qualifies as an important view, is it needed for a buffer? Now, I will say in these cases, even accepting if a passive use were to be true, those claims were discredited. But just going back to the larger picture, passive uses are not what the legislature intended. Taking objective opinions only would destroy consistency and uniformity, which is required by the Colorado Constitution. It's required by statute and uniformity in taxation. And again, the legislature has directed that these statutes are to be strictly construed in favor of the principles of uniform taxation.
Go ahead. Go ahead.
So, just a question. I'd like you to respond to Mr. Clayton's statement that the board appears to have hostility to these claims. I mean, if you just look, I sat here last week and there were very similarities in a different county. Do you think there are hostility to these claims?
I absolutely don't think that there's hostility to these claims because there were more than one case. I know in Eagle County, one of these cases, the Board of Assessment Appeals indeed found that there was use as a unit in conjunction with residential improvements, and there was absolutely no objective evidence of any physical use of the property, and that decision rested on the board's decision that the property was probably being used for a view. And not to focus too much on that case, but I disagree with the statement that the Board of Assessment Appeals
That case
expressed
is not listed in the list of cases that he's pointed out.
I don't know that it is. I think that that's an interesting question, and there are other cases from other counties. Eventually this court will see a cross appeal from another county where the board did find that a passive use was enough. So I very much disagree with that assertion by opposing counsel.
Ms. Hooper, let me follow up with my question. So you were discussing passive use is not sufficient in your view. And so what I'm thinking about practical purposes of having an adjoining property. And the words view and the words buffer would have absolutely no meaning unless they related to the residential parcel. And it would be common to enjoy a view or a buffer when you have a residence. So for practical purposes, this may be a common reason why someone would buy an adjacent property. And I understand it's your position, then it would not be used as a unit. But it has no meaning unless there is the residential property.
If I may, my position actually would be that that very well may be the enjoyment that a property owner gets from buying an adjacent lot. It's just that the legislature did not choose to give the benefit of the reduced residential assessment rate for just any reason that somebody buys and owns a piece of land. There are many reasons that people can do that. People can have as much land as they want and do with it what they choose. But that doesn't mean that they're entitled to the reduced classification rate that the legislature was very, very specific about. And especially if you read the statutory provisions as a whole, not just the definition of residential land at section 14.4, but also looking at section 14.3, which defines the residential improvement, and section 14.5. The intent together, reading these as a whole, is that there has to be something more for the resident, or for a parcel of land to receive this reduced assessment rate.
So looking at that legislative intent in the plain language, it says used as a unit, and it doesn't say actively used, or it doesn't have any modifier. So why would that exclude passive?
Well, the term use is defined, and it's briefed in the county's brief, and I think the board's brief as well, as it's to employ something. It by its term, and by its definition, means something more than just enjoyment. And I think that that's the difference. I think when we talk about passive use, we're really just talking about enjoyment of a property right. With respect to the word use, I think it's useful to think about some other contexts in property law that the word use is used. Consider, for example, in an adverse possession case, use is often a hotly contested issue. Would it be enough for somebody to say, maybe even, in one of these cases, I so enjoy looking out my window over at my neighbor's parcel that is this unspoiled land, or maybe it does afford me at this moment a view of high mountain peaks that will be destroyed if my neighbor someday decides to build. If I enjoy that view for a number of years and I let them know that I'm enjoying it and I don't want them to build a house on that lot, could then I construe that as I have used their lot without their permission for a period of time and somehow have a adverse possession claim? I think certainly not. I think we have to look at the word use in terms of property rights and what the legislature reasonably meant.
Ms. Hooper, then let me ask, if you're talking about legislative intent, are you getting to the idea that the legislature does not want land sitting vacant, that the used as a unit means something different than a vacant parcel, even though it's contiguous? Is that what you're getting at?
I think that the legislature intends uniformity in application of the laws. I think they want very specific and generally standards that people can understand and can be applied uniformly. And I don't think that a passive use or assertion of a passive use could lead to that result. I think that you would have parcel owners being treated very differently, or it's just eventually just a loophole that everybody who has a multiple parcel that has some thread of common ownership with somebody in the neighborhood or nearby in a close vicinity, according to appellants' definition of this land, would then somehow be able to come in and receive a reduced assessment rate, and that is definitely not the intent of the legislature. I just quickly want to say that opposing counsel greatly misconstrues the holding of the Gurman and Farney cases. First of all, under no theory and nowhere did the Gurman case say that facts can become established as a matter of law in classification cases when the same similar facts that opposing counsel is gleaning from that case are asserted. In fact, the case absolutely says the opposite of that. The court said the factual nature of the classification inquiry is determined on a case-by-case basis by the finder of fact. The court said that the BAA's evaluation of the facts presented is dispositive. It's up to the BAA to weigh the evidence. And in that case, we don't know all of the evidence that was presented to that court, the totality of it. We do know that it was a unitary parcel. On its own, it was a unit, and it had a residential dwelling unit on it. It didn't just have a residential improvement, because residential improvement includes dwelling units and things like fences and smaller, less important in the definition, I should say, improvements. But the court noted that in that case where it's a unitary parcel with a residential improvement, the only thing the property owner could do with that single parcel was use it residentially. And the board found that that was the only use of that parcel. Here, by contrast, the property is legally separate, not inherently a unit. It can be sold, developed, it can be left vacant. The lot line could be vacated. There's a multitude of things that the property owner could choose to do with that parcel, and it is not in line with the Gurman case, and it is not undisputed to just say that that is a case that establishes that assemblages of land should be treated the same. What I would close in saying is I ask you to affirm the board's finding here and appeal to you that the taxing entities and appellants community should not bear the burden of 4 years of tax refunds with interest at 12% a year based on a new interpretation of the law. Thank you.
Thank you.
May it please the court, my name is Katie Allison, registration number 39430, here today again on behalf of the Board of Assessment Appeals. I want to start, first, the subject land was properly classified in this case as what it is, vacant land. I want to start by addressing the petitioner's attack on the board. I want to talk a little bit about uses and the legislative intent. Regarding the attack on the board, I want to start by noting that the assessors are trained in assessments. They have a lot of training. The ARL gives them additional guidance. They go out there, they make their assessment, and they have that training, whereas the petitioners don't necessarily have any training in that sort of, in the questions that the assessor is dealing with. So we already have a heightened training that the assessor has. Then the BAA reviews the case, and the BAA does often affirm the assessor's determination, but it also rejects the assessor's determinations in cases. And in these cases, the board has, like we have discussed, has gone up both ways on these cases. But what you're seeing here are sort of the tip of the iceberg cases. And the facts of this case are actually quite illustrative of the board's reasoning in these cases and why their orders are supported. In this case, we have the view. The Donahughs claimed that they sat on their hot tub patio and looked out over their subject lot to, they first claimed that they looked to the back bowls at Vale. As the evidence sort of came in, they realized that their view of the back bowls at Vale was actually straight ahead. And so they sort of changed, and they said, well, we look at the high mountain peaks that are over this direction. And then as the evidence came in, the testimony sort of changed and said, well, we can't actually see through the trees that you all have noted. And we're actually looking at the hillside. We're actually enjoying the hillside that we can see of the subject lot. Well, as the evidence came in further, it's clear that the hillside that they're looking at from that hot tub is actually on the residential lot. The views that they ended up talking about here are on the residential lot, and I would direct you to exhibits 12 and 14 in the record, which show the views directly from the hot tub. Another claimed use was sledding, and Mr. Cassidy went to the lot several times. He saw no evidence of sledding, but even if there was a little bit of sledding, that would be an occasional use that under the Rust standard is not sufficient. And also, the evidence in the record was that the sledding was actually occurring on the residential land, not on the vacant land. And that's another case where the assessor has training to know where the lot line is to see what might actually be occurring on these properties. It's also illustrative in many of these cases that these property owners have not vacated the lot line. They have not integrated the residence. If they had done so, this inquiry would be a lot easier. Again, the claimed uses in this case were not credible. They were not sufficient to meet the use as a unit in conjunction with the residence standard. And the board was not wearing foggy glasses in these cases. I want to talk about, Judge Furman, you asked, does the legislature are they encouraging non-vacant land?
I was asking if that was a position of Eagle County.
Okay. Well, my interpretation of what the legislature is seeking here is they are giving an exception to residential land. They give an exception to residential land and agricultural land, a lower tax rate. So they are favoring residential land. And these cases are vacant parcels. There is nothing on these parcels. They are entirely vacant parcels. And I want to talk about the uses, the passive uses that we're talking about that are occurring on these entirely vacant parcels. And I pose the question, are these actual uses? Because do I actually use something by simply looking at it? Do I actually use something by looking out over it? Am I using your chair, Judge Roman, by looking at it? I don't think so. And in these cases, the petitioners are actually keeping the property from being used. Their claimed use of the property is to keep it from having a residence put on it. That is keeping it from having a use. That is the opposite of the use. I ask that you affirm the BAA's order because it is supported by substantial evidence and is reasonable basis in the law.
Thank you, counsel. Thank you all for your fine arguments. The case will stand submitted, and an opinion will issue in due course. That concludes the 1:30 docket. Okay. We're going to take a short break. We'll be in recess, and we'll be right out in a few minutes. So the bailiff shall so announce. Please be seated. Good afternoon. This is Division 5. This is the 2:30 docket. I see that council are present and council were here for the 1:30 docket as well and argued those two cases. So I don't have to go over the rules or the protocols with you folks anymore. I think you know exactly what we're doing and what's expected. So with that, I think we will go right into the 2:30 case, Neuhoff versus Board of County Commissioners, 17CA0762. Mr. Clayton?
Thank you. May it please the court, I'm Britt Clayton with Riley Carlock and Applewhite, registration 15940, representing the Neuhoff family. Rarely in these arguments have I been taken so far off of my planned course and yet with so much profit to the discussion. So I'm going to pick up a couple of things I missed earlier that...
Let me ask you this. Is the pre-argument questions, is that what's contributing to that?
No.
Okay, good.
It's just a really unsettled, interesting area, and I appreciate the questions and the diversions. Let me go back and talk for a moment about the Gurman case. It really is critical importance to our claim and our theory here. One must appreciate the procedural posture of Gurman. The board had found that this entire 36-acre parcel was entitled to residential classification because the homeowner said, I want to keep people off of it and like to look at the wildlife out there. The county appealed and said that's insufficient. And so the court's question was, is that a legally sufficient use to satisfy this used as a unit element? Court said, yes, it is. The inescapable logical and legal consequence of that analysis and ruling is that these passive uses are sufficient as a matter of law to satisfy the statute. And what it means to be a society governed by laws and principles is that if this type of passive use is sufficient for the Gurmans, it's also sufficient for the Donahughs and the Blyas, the Neuhoffs. That's what sufficient means. You don't have to show more. It is sufficient. And that's what Gurman says when you follow the logic of it. These minimal passive uses are sufficient as a matter of law. And that principle applied in the multi-parcel context resolves these cases. It really does. It doesn't require an attack or a critique on the board, by the way. And I want to acknowledge that in one case in Eagle County, the board found that the taxpayer's view corridor satisfied the element, but then ruled against the taxpayer on the other two elements. So I don't know what all that means. And in La Plata County, Routt County, excuse me, one of the panels of the board found that the taxpayer had passive uses that satisfied residential classification for a part of the property. So there's a more complete story, but the 18 cases that I've cited to you still have to be considered and taken into account when we make a rule, a principle that can be applied on a uniform basis. We discuss uniformity in our briefs as well, and I submit to you that it is promoted, not inhibited, by applying the Gurman standard, this low standard which 99% of the families appearing in good faith will satisfy. Because you don't buy the parcel next door and pay taxes on it for years and years when you're not getting any use or enjoyment out of it. The ARL is not controlling here in any fashion, but keep in mind that one of the ARL factors the assessors are admonished to consider is the primary use of the parcel for the use, enjoyment, and other non-commercial activity of the homeowner. that use and enjoyment and non-commercial activity reflects a fairly low threshold. It's consistent with our reading of Gurman and the statute. Let me bounce for a moment. This is not quite linear, but let me go back to the Rust case, and I was not able to explain the second reason why the Rust decision is erroneous. Rust concludes that a different standard applies in the multi-parcel context because the ARL reasonably imposes an additional requirement, quote, additional requirement, that the undeveloped parcel must be integral to the residence. There are multiple problems with that conclusion. The word integral does not appear in the statute. The DPT has no authority to create an additional requirement by suggestion in the ARL, and courts likewise have no authority to add requirements to a statute. The Rust opinion finds it reasonable to impose this additional requirement, but it is inherently unreasonable and impermissible to violate a canon of statutory construction by adding words of limitation.
Well, Mr. Clayton, sorry to interrupt. Could we use a term to define a term? Meaning it's a synonymous, it means the same thing. We're using these principles, these ideas to explain?
Yes, and Kurt Settle testified exactly to that effect. Now, as I mentioned, the Summit County trials in the BAA did not have the benefit of Kurt Settle's testimony. But here's what he said in the trial in Donahugh, and there's similar testimony in Neuhoff, about the second bullet point in the ARL, which uses the term integral. Question: does the word integral, which appears in the bullet point here, appear in the statute? Answer: it does not appear in 39.1, 102, 14.4. Question: is the word integral meant as a synonym for the used as a unit in conjunction with the residential improvements? Answer: yes, that's the concept we're trying to portray. Question: are you aware that in some contexts, integral might mean essential or necessary? Answer: yes, I've heard that. Question: is it the DPT's position in having us interpret the ARL that integral is synonymous with essential or necessary? Answer: we do not say that. So, to your point, Judge Furman, what the ARL is doing is using this integral word as a shorthand, just a shorthand, for a synonym for used as a unit in conjunction with the residential improvements. And I have no objection to that kind of shorthand, but the Rust panel interpreted it as an additional requirement, and it's not even clear what that requirement is. And that was done without the benefit of Mr. Settle's testimony, but it just is not supportable as an additional requirement. If we want to use integral as a label or shorthand for the statutory element, I have no problem with that.
Well, Mr. Clayton, let me follow up on that. So the evidence in this case from the assessor was views might be negatively impacted, but it just wasn't enough to say they didn't still have views. Is that what the assessor was speaking to, was the idea of integral?
I don't know that the assessor, the assessors have generally interpreted integral to mean necessary or essential. But I think at a minimum, what they interpret the statute and the ARL to mean is something necessary and important, which empowers them to decide. This is the fundamental problem and the criticism I have of the assessors and the BAA. It is not their role to decide whether the Donahue's appreciation of views is important enough to satisfy the statute. They are using it as an excuse to deny classification instead of being open to it, as I believe the General Assembly would want them to be. Buy another parcel to augment your home. Makes total sense to me. Love it. Welcome aboard. Let me turn, this is a good segue into one of the questions of the court in this Neuhoff case. What is the What purposes underlying section 102.14.4a should convince us whether or not the legislature intended the term used as a unit to have a different meaning depending on whether single or multiple parcels are involved? Great question. I'm astounded that the parties got this far along without answering that question. In 1982, Colorado taxpayers voted for a constitutional amendment called the Gallagher Amendment, which created this preferential tax treatment for residential property. Residential property values had risen faster than other types of property values, and as a result, homeowners were bearing an ever-increasing share of the total property tax burden. The people of Colorado adopted this amendment to basically hold residential values at the same level or percentage of total values in calculating the tax burdens. What has happened as residential values continue to increase is the assessment ratio on residential property has been incrementally adjusted downward, periodically adjusted downward by the General Assembly as required by the Gallagher Amendment. So that's how we got to today, where in these cases the residential assessment ratio is 8% and the assessment ratio for all other properties 29%. That's a 3 times plus, or a 1/3, plus difference in the tax burden, and that is the economic motivation for why these parties are debating that issue. But back to answer the court's question, we need to interpret this statute recognizing that it is implementing the people's will in the Gallagher Amendment to give homeowners a break on residential land because homeowners were bearing what the people considered to be an excessive share of the burden. Now, with that understanding, why in the world would you treat multi-parcel homeowners any different? Can you imagine a voter in the ballot box thinking, well, we don't want to give multi-parcel homeowners the same benefits as single parcel? Can you imagine the General Assembly doing that? And then certainly nothing in the statute suggests that that's the case. This was an encompassing and inclusive benefit for residential homeowners. It should not be construed strictly, as Ms. Hooper has suggested. If anything, it should be construed in accord with its beneficent motivations and its fundamental desire to give homeowners a break on their residential property. And because multi-parcel homeowners are just the same kind of folks and they make the same kind of uses as single parcel homeowners, they should get the same treatment. I will reserve my remaining time if I may. Thank you.
Very good. You have 3 minutes and 5 seconds. Ms. Hooper? You'll be dividing your time again, is that right?
May it please the court, my name is Christina Hooper. My attorney registration number is 38271. I'm representing the Eagle County appellees and will share my time with Ms. Allison representing the Board of Assessment Appeals. So the issue in this case is actually the classification of 2 unimproved parcels of land. The appellants have contended that they've met their burden to show that these properties were used as a unit in conjunction with the residential improvements because the taxpayer asserted the primary benefit and use of the properties is to prevent development and protect views of the meadow and to protect privacy, and because there is no commercial or other use being made. The only evidence presented to support these assertions were the assertions themselves and the testimony of a fact witness who was paid on a contingency fee basis. In the record, it's uncovered that these property owners were solicited by direct mailing by tax agents acting on a contingency fee basis, asserting a novel interpretation of the law. The board didn't find the evidence credible. They didn't believe that the lots were used as for the purposes that petitioners claimed. I'd like to start with a response about Mr. Settle's testimony and the import of that testimony. You heard portions of the transcript were read to you. It's improper to even be relying at all on Mr. Settle's testimony. The assertion that his testimony concerning possible interpretations of the ARL or what it should mean, or that it would change the outcome of the Rust decision is absolutely misguided. Mr. Settle was offered as a fact witness. Over objection of the county, he was allowed to answer a series of leading questions about the history and the intent of the ARL and the language of the statute, to which it was revealed, or, in that same record, he had no foundation or knowledge for. Mr. Settle was not part of the legislative drafting of subsection 14.4. Mr. Settle was not involved or employee of the Division of Property Taxation when those ARL provisions, the bullet points and the interpretation of subsection 14.4 was drafted. He had no legislative history on the issue of use. To the extent that his testimony conflicts with the plain language of the ARL or attempts to modify it, extend it, interpret it beyond its plain words is 100% irrelevant and not entitled to any deference. For an interpretation to make it into the assessor reference library, it's very important to understand that by statute, the ARL has to go through a particular process to even be published. This is manual guidelines that assessors are required as a matter of law to rely on. An interpretation first, or any amendment to the ARL, first has to be approved in a public process by the Statutory Advisory Committee. It then has to be approved by the State Board of Equalization at another public hearing. And then it has to be approved by the Legislative Legal Services team for compliance with the statutory directives. None of this all happened with what the ARL says now, the words that we have to rely on. None of this happened with Mr. Settle's opinion that may have been elicited through the leading questions of opposing counsel during the hearing. So therefore, the testimony really has no bearing. It has no, it is actually entitled to much less deference, if no deference, over the Board of Assessment Appeals interpretation. They are charged with interpreting these statutes, and their interpretation is entitled to great deference. I also ask, in reading that transcript, it is ironic that opposing counsel is just very selective in picking the parts of that testimony that they would like you to rely on at this point.
Ms. Hooper, can I turn your direction to the other question, the pre-argument question? So when we were discussing the other case, for instance, the one with the wrought iron fence, and we were talking about the future sale and the use of the property. Now, we don't have any type of barrier in this case like a fence, and we don't have a sale of a property. We have a property owner saying, I really wasn't contemplating selling it, and if I did, I would sell it together. And we have an assessor saying, well, in the valley, there's only a few lots available, so they'd likely be sold separately. What relevance does that have to the current use of the property on the assessment date?
I think it's a very legitimate and objective consideration for the assessor or one of his trained appraisers to think about when they're out inspecting a property. The question is aimed at looking at whether the parcels function as a unit. If indeed there are two parcels, one with a residence on it and another that is being used in conjunction with that residential parcel, then most willing buyers and willing sellers would see them as selling as a unit. So I think that that's what this is trying to do. Appraisers are trained in their experience and in their training. That's what they do. They look at how the market would treat properties. And for example, I think that they're supposed to be thinking about, now if in this situation, Mr. Neuhoff wanted to, or the Neuhoff family decided to sell one of these parcels, would a buyer come and say, wait a minute, you're only selling me a portion of the whole. This doesn't make sense. You need to sell the whole thing. Or could these really just be sold off individually? And I think that that's what the question is intended to look at. It's not just specifically focused on the intent of that particular property owner. It's looking to see how they function as a unit.
So if I understand, you're saying the focus is on a reasonable buyer or seller in the future, what they would do.
Yes, just a reasonable buyer and seller as of the assessment date, even. If the parcels are functioning as a unit, then they would reasonably be sold together as a unit. In terms of answering another question, what purposes underlying 39.102.14.4 should convince us whether or not the legislature intended used as a unit to have a different meaning dependent on whether there's a single or multiple parcel involved. The used as a unit term doesn't have a different meaning depending on the number of parcels, but it has a different application. That's because for a single parcel, the inquiry is whether the parcel, a unit itself, is used in conjunction with the residential property. The residential property has to have a residential dwelling unit. It cannot just have a residential improvement. And so for a single parcel, that's the inquiry. For multiple parcels, the inquiry could be different. It depends on whether that contiguous parcel contains improvement or does not contain an improvement, and it depends on whether it's employed in some way as a unit that's obvious. So that's the first thing that I will say about that. So for the multiple improved parcels here, we need some sort of credible, tangible evidence to see that they're being used as a unit. With that in mind, turning to the purposes of subsection 14.4, in the Vail Associates case and in a recent O'Neill case, the legislative purpose, I think from legislative history, was described as to grant homeowners a modicum of tax relief. So I will say that that is the legislative purpose. There is also an underlying purpose I've said already, which is uniformity in taxation. But I'll start with the legislative purpose. The legislature chose to grant this homeowners what is synonymous with a small amount of tax relief. They did not choose to grant this benefit to all property owners that have property zoned residential. Under appellant's theory, why would they have not done that? If they want to give every residential parcel owner a break, then they would have done that. They would have drafted this language this way, but that is not what they did. It was a very limited exception for a limited purpose, and it has to be strictly construed under 39.1.101. The legislature did not choose to grant this benefit to any property owner enjoying land. The legislature did not intend to create a tax loophole, and they certainly didn't intend to create a system where the property owner's assertion, years after the fact, about subjective beliefs would subject taxing entities to a very large tax refund with a very large rate of interest. And that brings us to the underlying fundamental purpose here, which is uniformity in taxation. Let's talk about the application of 14.4 in a single parcel context. If a property owner comes in and says, "Assessor, you have misclassified my property for the last 3 tax years," the assessor is required under law to say, "Okay, I need to find out as of which assessment date you had a residential dwelling unit constructed or be under construction on the property." For a single parcel, the assessor is going to have to require objective evidence. They can't just say, "I see now that you have a residential parcel in tax year 2018, so I will grant you a tax exemption or a reduced residential rate going all the way back to 2013 because you probably had that residential dwelling unit as of that time." No, they need objective evidence supporting that use as of the assessment date. For multiple parcels, if a physical use was the thing that the homeowner came in and said, "Look, I have this, my property has been misclassified, I incorporated it, I have this patio, I fenced it in." Again, the assessor doesn't just say, "Okay, well, thank you for letting me know. Now I'll go back and reclassify your property and give you a tax refund." We have to look at what was happening as of January 1st with tangible physical evidence. And now appellant is asking you to treat multiple parcel owners who just assert some sort of objective or subjective, passive enjoyment of a property differently and say, "Well, because we've asserted this use today, we ask for a refund going back for 3 to 4 years." We assert there is just nothing based on the legislative purpose to give homeowners a small amount of tax relief and the fundamental purpose of uniformity in taxation. There's no basis to be treating these multiple parcel owners differently when they assert a non-observable use. So the other thing that would happen is we'd be treating the Neuhoffs who's using the land just in their subdivision just as the 2 other vacant parcel owners are using their land. They're just vacant, untouched land, and there is no uniformity to say just because the Neuhoffs have asserted some sort of enjoyment over those properties, that should receive a different tax rate than the other two vacant parcels, where perhaps people are just, saving capital to eventually build their retirement home. Maybe they have plans ready to go, but until they build that residential dwelling unit, they are not entitled to the reduced classification rate. We ask you to affirm the Board of Assessment Appeals decision in this case. Thank you.
May it please the court, my name is Katie Allison, registration number 39430, here today representing the Board of Assessment Appeals. Your Honor, the subject land in this case was properly classified as vacant land because it was not used as a unit in conjunction with the residential improvements thereon. I want to jump right in and briefly talk about the question that the court has asked to us about single or multiple parcels, and I want to point directly to the statute, because I don't think we even need to look at legislative intent. I mean, that helps, it informs a lot of our inquiry here, but the legislative purpose is reflected in the plain language of this statute. Residential land means a parcel or contiguous parcels of land under common ownership upon which residential improvements are located and that is used as a unit in conjunction with the residential improvements located thereon. Under this statute, the residential parcel must have a residential dwelling unit on it under the Vail Associates case. And the vacant parcel has its own requirements. It has common ownership requirement, contiguous requirement, and we can look at the plain language of the statute and not look further. If we do look further, there's obviously a rational basis here with one parcel being fully integrated, and if we're talking about multiple parcels, they are not fully integrated, as Ms. Hooper has discussed. I also want to address this, another question that the court has asked about the ARL factor conveying the property in the future. Under the ARL, the primary criteria for classification include current use, zoning and use restriction, probable use, and reasonable future use. And so I do think in some cases reasonable future use can be helpful to us. This factor addresses the probable use and the reasonable future use, but it also addresses the date of assessment, because as Ms. Hooper discussed, we're talking about whether these two lots function as a unit in the market on the date of the assessment. I also want to take a step back here and look at the big picture. We're talking about money here. The petitioners would receive a significant tax break on their property. And in this case, they aren't actually using their unit or their lot as a unit in conjunction with their residence. Instead, they want to pay lower taxes. And that's a credibility determination that the board gets to make. And no one here is telling petitioners that they can't use their property as they want to use it in these cases. If they want to use it not to build a house on it in the future, that's completely fine. But they should pay taxes on their property based on what the land is used for. Here, the land is used to be kept vacant. The taxes should be assessed accordingly, and we ask that you affirm the Board of Assessment Appeals decision.
Thank you, Ms. Allison. Mr. Clayton?
Thank you. A picture is worth 1,000 words. This is page 5 of the opening brief, and you'll recall this image of the Neuhoff's home, the residential parcel, and the two subject parcels in the meadow. Imagine that it's all one parcel. Nobody would doubt it. Gurman says it's 100% residential classification. Instead, we have some parcel boundaries in there. And now the property owner is exposed to the assessor coming around and saying, hey, if houses were built there, you'd still have views. Look, you could look between the houses and you could look around the houses, so your views, they're not that important. And in terms of privacy, I mean, you've already got houses scattered all over this valley. What's a couple of more? Right? It's just not important enough. And the BAA says, that's very persuasive. That's very credible. There's something really, really wrong here about how you go from basically a presumption of residential classification unless there's some non-residential use, which none of these cases have. You go from a presumption, and it's all okay, and nobody's coming around and saying, you don't need this and you don't need that, and now it's 3 parcels, and it opens the door to all of this nitpicking and denial of classification. And we're asking ourselves, well, don't we have to defer to the board's, credibility findings? Everything is solved, everything is simple, everything comes out right if you just hold that Gurman applies here. Just do the same thing you would do with a single parcel. That's what the General Assembly wrote in the statute. A parcel and contiguous parcels under common ownership, used as a unit. It's the same element for both situations. It's the same language, grammatically, syntactically, it's the same. Nobody has advanced a good reason why it should be a different standard, other than, well, it's vacant land. Look, it's vacant land. Well, I know, but if it was a single parcel, it'd be the same, be the exact same land. It's the same people. It's the same land. It's the same statutory element. Everything about it is exactly the same, except they think that in the multi-parcel setting, they get to come in and write new rules to make it harder, to change the whole game, to tell people what's important to them and what's not. What this court needs to say is what the court said in the 1990s. It's not up to the assessors to make those kind of decisions. It's basically a presumption, unless there's some non-residential use. Apply Gurman and Farney here. It's simple, a small step, everything comes out right. Thank you.
Thank you, Mr. Clayton. And I want to take a moment to thank all 3 counsel for your excellent arguments over the span of 3 different cases with some similar issues, some that were not, but they were all very helpful to the court. So thank you all for that. The case will stand submitted and an opinion will issue in due course, and that concludes the court's docket for today. The court will be in recess and the bailiff shall so announce.